federal agents who attempt to enforce an unconstitutional federal act. The bill would also encourage Texas prosecutors and law enforcement to use the existing Texas Official Oppression Act against federal agents violating the rights of Texans. Texas Attorney General would be authorized to defend the state to prevent the implementation and enforcement of an unconstitutional action. Members, House Bill 796 is an important bill to make certain that we can explain why we do the things that we do. It gives us a process. With that said, I believe there is an amendment.
Mr. Speaker.
Mr. Turner, for what purpose?
Mr. Speaker, with the gentleman yield for some questions.
The gentleman yield for questions.
The gentleman would yield for questions.
Gentleman yields.
Thank you very much, Chairman Bell. I know we discussed this bill when you laid it out in the State Affairs Committee a few weeks ago. I wanted to continue that conversation this afternoon. So basically, by establishing this joint legislative committee, this committee will be empowered by the state of Texas to review and evaluate federal actions, whether that's an act of Congress or an executive order by the president. Is that right?
That's my interpretation of the bill as well.
And I think I left one out. It also would apply to review of federal court decisions. Is that true also?
Supreme Court, I believe, is called out. Yes, sir.
I'm sorry, I didn't hear you.
I said I believe SCOTUS is called out. Supreme Court is called out.
The Supreme Court is also named in the bill. All right. So what would be an example of a federal action, whether it's a law, an executive order, or a court decision that this committee could review?
So in Texas, we have a law on our books, the Any Willing Pharmacy Act, that says that if you have a pharmacy near your location, you can go to that pharmacy and get your prescription filled. But in Texas, we don't follow that law, even though it's on our own books. We instead follow our contracts with our different providers. And this act has gone through the Fifth Circuit, through the courts, and in Kentucky was resolved, I believe, to determine that is, in fact, the federal legal standing is that you should be able to do that. This bill would simply say, if we're going to not allow the members of Texas, citizens of Texas, to be able to act in that manner, why? That's literally what it would do.
Okay.
Puts in place a policy for us to understand why it is that we are doing what we are doing.
Okay. Well, I understand that trying to answer the question why, but I think it goes further, right? So if this joint legislative committee makes a determination that a federal law, executive order, court ruling is inconsistent with the Constitution in the view of this committee, then they can essentially recommend to the legislature that the legislature pass a measure to say we're not going to follow the federal law, executive order, or court opinion. Is that true?
It would provide the process whereby we would validate our actions.
By validating our actions, you mean to invalidate the federal action. Is that right?
If that's been our action, that would be the consequence of that, as is the case with the example I gave you a little bit ago.
Well, so let me, and I appreciate the example you gave. I think that's a pretty narrowly tailored, maybe somewhat obscure example, which may well be relevant. But let's talk about a potentially a big action. Let's talk about, say, the Affordable Care Act, also known as Obamacare. So, could under your bill, could the Joint Legislative Committee review the Affordable Care Act and say, you know what, we don't think, in our opinion, the Affordable Care Act is constitutional, even though the Supreme Court's upheld it repeatedly, and therefore we're not going to allow the Affordable Care Act to be enforced in the state of Texas? Is that the end result of what could happen from your bill?
I think anytime we speculate on outcome, we're doing just that. We're creating a speculation. But in your example, it would create a process. If someone with standing had created the question, then the question would go through a process whereby this body, sitting right here, and our counterparts across the rotunda, would determine why we did what we chose to do. In the case of following the Affordable Care Act, when you choose to follow it, that's a determination, but you can't tell any of your constituents why you chose to follow or not to follow things that may be questionable to the society we live in, to the population we live in.
Sure.
This bill 796 simply creates a process whereby we can explain why we take the steps we take.
Well, and I appreciate that, and I'm not asking you to speculate what this committee may do if it's established and what a future legislature may do. I'm just asking you, is that possible? Is under your bill, is the scenario I described a possible outcome?
So again, this body would make a determination if someone brought it to this body. The way it's created,
it's possible.
It would be put into the process. The 150 folks on this side and the 31 on the other side would have to determine if indeed Texas elected not to comply. We would have an understanding of why we made that election.
Okay, so it's possible.
It is.
If it followed all those steps.
It could follow that process.
Okay, thank you for answering that. So,
Yes,
so my concern, Representative Bell, is the constitutionality of this, because this strikes me as I think back to my American history classes a long time ago. This strikes me as basically a nullification effort. So, nullification was hotly debated in this country in the 1830s during President Andrew Jackson's time, and there's a senator from the South, John C. Calhoun, who advocated for the state's ability to nullify actions of the federal government. That was in the context of slavery. And Jackson quashed that because he felt very strongly that the U.S. Constitution, through the Supremacy Clause, established that the federal government is the supreme law of the land. And so when state law conflicts with federal law wins. And so it seems like we're bringing back the nullification debate from nearly 200 years ago with this bill. And I guess my question is this essentially an effort to nullify actions by the federal government?
it's an effort to be able to explain why we take the steps that we take. Because whether you use any example you want to use to apply it to it, in the end, Texas does what Texas does. You can go with a lot of different examples of where Texas has had a federal edict to do certain things, and we've elected to not fund those. There are a number of instances where the funding is tied. Basically, this particular bill would simply provide an understanding of why Texas does what it does. We would be able to leave this body and say, if our determination was not to do something, that it at least went through this process, not that it was randomly applied or not applied.
Well, but I think your bill goes further than just providing an understanding to the people of Texas. I mean, your bill says if a federal action has been deemed unconstitutional by this body, which is not a court of law, I would note, that the action would have no legal effect in the state of Texas, and a political subdivision of the state and the state itself can't enforce said federal law or executive order. So it seems like it goes beyond just an understanding of how we feel about it. It seems like it has a real direct impact on whether certain federal laws are going to be enforced in the state of Texas. And my concern is that it sets up a really predictable and avoidable conflict with the federal government that I don't know is a great use of state resources.
Well, and I will say this, you used the term the Supremacy Clause. Constitution does include that aspect. It also says federal government does not have the authority to act outside of its enumerated powers and authorities. So I think what happens
Absolutely.
is
I agree.
When we have a scenario where there is a question on the part of this body of how we're going to act, this presents the opportunity for us to be able to identify why it is that we came to the conclusion we came to as a body, whereas right now there is no process, simply outcome or lack of outcome, and in many cases kind of a randomized approach to how we view those scenarios that may be in question.
Okay. Well, I appreciate that. Again, I feared that this measure takes us down a road to nullification, that an issue that was debated and really decided in this country before the Civil War even. And if you go back more than 200 years, in the case of McCullough versus Maryland, the Supreme Court in that time, in the year 1818, ruled that federal law is supreme when there's a conflict with state law. So this is not this is a pretty well litigated and decided matter of when there is conflict between state and federal governments. The federal government prevails due to the Supremacy Clause and due to the way the U.S. Supreme Court has ruled in these matters over the years. Acknowledging, and I fully acknowledge what you said, there are limitations, as there should be, on federal actions, but where there is a conflict, particularly with respect to interstate commerce, federal law is supreme. And I fear that your bill puts us on an untenable path towards a lot of litigation and unnecessary conflict down the road should the legislature pass it. But thank you for answering my question.
Thank you. Yes, sir. I believe there's an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Tinderholt.
The chair recognizes Mr. Tinderholt to explain the amendment.
Thank you, Mr. Speaker. The amendment simply ensures the majority of the members of the committee are members and the minority party are a respective legislative body. It's acceptable to the author, and I respectfully move adoption.
Mr. Tinderholt sends up an amendment. The amendment is acceptable to the author. Is there objection to the adoption of the amendment? The chair hears none, and the amendment is adopted. The chair recognizes Mr. Bell to close on the bill.
Members, thank you for your time. Move passage.
Question occurs on passage to engrossment of House Bill 796. This is a record vote. The clerk will ring the bell. Show Mr. Schofield voting aye. Have all voted. There being 86 ayes, 61 nays, House Bill 796